Oh, absolutely. Point of personal privilege from Senator Gossage.
Thank you so much, Mr. Chair. I would like to introduce two of our high school students from Eudora High, Jag K, and they're Mark and Noah. Wave. Yay! And their teacher, Miss Chance, who's with them.
Thank you, Mr. Chairman, members of the committee. SCR 1611 is a concurrent resolution proposing to amend the state constitution. These amendments would be in Article 3 regarding the Supreme Court for the state of Kansas. The primary amendment is there on page 1 of the bill, and it would add new language that would require that the justices of the Supreme Court be elected on a statewide basis. Under current constitutional provisions, there's a Supreme Court nominating commission. The nominating commission nominates 3 individuals, submits those names to the governor, and the governor then appoints one of those 3 individuals to the court. The nominating commission would be abolished under this constitutional amendment in place of a statewide election of the justices to the Supreme Court. There are 7. The positions would be staggered in election under the amendment language. So positions 1, 2, and 3 would be elected at the general election in November of 28. Positions 4 and 5 would be at the general election in 2030, and positions 6 and 7 2 years later in November of 2032. They would then be up for re-election every 6 years afterwards. There is a provision that if there's a vacancy in any of the positions before the term expires, then that vacancy will be filled at the next even-numbered year election to fill the remainder of that term. The remainder of the stricken language on pages 1, 2, and 3 is to remove the language regarding the nominating commission, which would be abolished under this amendment. And then there are amendments to Section 8 of Article 3 on page 3. This is simply to remove language that currently prohibits justices who are appointed from engaging in partisan organizations, including holding office in a partisan organization. So that restriction would be removed and allow them to take part in those political campaigns. And then finally, there's an amendment to Section 15 that simply strikes a reference to the nominating commission that is being abolished. Again, because it's a concurrent resolution, requires 2/3 of the members of both the Senate and the House to approve the resolution before it can go to the general election ballot. Under the bill as introduced, it would go on the general election ballot in November of 2026 for approval by the voters at that election. With that, Mr. Chairman, I'd be happy to stand for any questions.
Thank you, Jason. I think we have questions from committee. I know Senator Blue is online, WebEx, and has a question. Senator Blue.
Thank you, Mr. Chair. Jason, for our current, and if you...
You're cutting out, Tori.
Supreme Court, do they position already the numbers? Positions 1, 2, 3, 4, 5, 6, 7.
Oh, yeah, she has a question about the positions that we are mentioning here. I think those are numbered by the court. Is that correct, Jason?
The court does have numbered seat positions for its own administration. The constitutional amendment does provide that the designation of the position numbers for election purposes would be as provided by law. And so the legislature could adopt a law, could enact a law that specified which seat numbers were in which positions for election in 28, 30, and 32.
Committee, any other questions? Senator Francisco.
Thank you. And thank you, Revisor Long. If we talk about the statements that are printed on the ballot, the statement about saying a vote against this proposition would continue the current system whose membership consists of a majority of lawyers. Can you help us understand who is on that nominating commission?
I don't have the list of who is on the nominating commission currently, but we can certainly get that information to the committee.
Thank you. I think it would be more clear to talk about who's on it than to talk about a majority.
And perhaps some of the proponents or opponents might address that as well, Senator. Any other questions? Seeing none, thank you, Jason. Appreciate that very much. We're going to move into the proponent in-person testimony and 23 minutes. And first up, we have Senate President Ty Masterson to kick us off. Mr. President, welcome to Fed and State.
Thank you, Mr. Chairman, Ranking Member Fauskido, distinguished members. Thank you for giving me the time. Thank you for letting me go first. You guys have my written testimony, and I know you can all read, so I'm not going to read that to you. I'll let you peruse that. I'd really like to just briefly address what I believe is going to be the presented objection, which I think is false, which is that somehow this is a power grab of some sort. And the only context in which that is true is it would be taking power from an elite group of lawyers and giving it back to your constituents. I mean, that's really fundamentally where the power shift happens because it was transferred in that direction. The truth is, we're the only state in the nation that gives this superpower to a small group of lawyers. There's other Missouri models, but we're the only one that does that where the majority is a small group. So it doesn't matter if we have a Republican governor or a Democrat governor, the power resides in a handful of lawyers. And we've given this superpower to a small group. That power belongs to your constituents. And that is what it gives them. And by the way, you are not taking this action and amending the Constitution. You're putting this on the ballot for the people to have a decision of whether or not they want that. And we need to give that to them. And I tell you what, it's done. What this model has done has given us the most overturned court in America, right? That court has developed a stance that has been the most overturned. And it's very acute in Sedgwick County because there was a case with the Carr brothers, right? That they were a heinous set of brothers that murdered a group of people. And our court went through all kinds of machinations to try to set that aside. Even Ruth Bader Ginsburg, who's not God rest her soul, was obviously one of the most progressive members ever of the U.S. Supreme Court, used critical terms like flawed logic. So it is not developing the court, I think, as they saw it, decades ago. And the truth is, elections are how we govern from the bottom up. Right? It's putting the politics where they belong. They're going to tell you, oh, it's putting politics in the system. Don't be kidding. Politics are in the system. That's the worst kind of politics. It's veiled. It's in the black box, behind the closed door, how you want to see that. But it is putting politics out in front, how you and I are elected. Because when we're bestowed with powers, right, to represent our people, that's how you actually you vet the people that you're giving the power to. And so elections are the proper way to do this, even in the judicial branch. So don't buy into that somehow this puts politics into it. Politics are in it. It's just in the darkest vein of it, which is in the small black box. So I encourage you to support this. I do believe there's a technical amendment setting out there. I say technical, it's clarifying language. I would urge you to consider that. But that's why we do this process, right? That's why we go to committee. That's why you work through the bill. But I would encourage you to support it because elections are the way. And we're not strangers to it. In my area, we elect our district judges down in the 18th, and it has delivered high-quality judges. It has not delivered what people try to scare you with of some type of dangerous politics, and so we're used to it. So I just encourage you to support this and give your constituents the choice, and I would stand for questions at the appropriate time, Mr. Chairman.
Thank you, Mr. President. I think we'll hold for questions so we can ask in a block if that works for everyone, and then that'll be the best way to do it. Thank you, Senator President, Mr. Messerman. Ty. Next up, the Attorney General, Chris Kobach. Mr. General, welcome to Fed and State.
Thank you, Mr. Chairman and members of the committee. For the past 67 years, Kansas has been engaged in an experiment, and I would pose the fact to the committee that the experiment has been a failure. As the Senate President mentioned, Kansas is the only system in the country. There are 13 Missouri model systems for selecting Supreme Court justices, but ours is the only one that added the extra step of giving 5 of the 9 seats, and it's in Section 5C of the current language of the Constitution, Senator Francisco, that specifies 5 of the 9 seats go to lawyers. Every so often, as a member of the Kansas Bar, I get an envelope in the mail. It's usually a surprise because nobody even knows when the dates are that you're going to get it. And I'm given these names, and I get to vote for these names to be on the commission. You don't get that vote. No one in this room gets that vote unless you're a member of the Kansas Bar. It is an elitist system, and that elitist system was designed by lawyers. It is obviously controlled by lawyers, and I would suggest it reflects the political biases of lawyers. It was designed in 1958. In the 30s, 40s, and 50s, those are often described as the progressive era of America, not progressive like we use the term today, meaning left-leaning, but progressive meaning you take things out of the hands of legislators, out of the hands of voters, and you put them in the hands of so-called experts. And that's what the Missouri model was, only Kansas took it to an extreme, again, being the only state in the country that does this. But I would say that the elitist system produces poor decisions. It's the most overturned state Supreme Court in the country, as the Senate President mentioned, and I can put a number on that. Since 2007, our Supreme Court has been overturned 87.5% of the time it goes to the U.S. Supreme Court. In the infamous Carr brothers case, the U.S. Supreme Court described the reasoning of the Kansas Supreme Court as follows, quote, untenable and based on the most extravagant speculation beyond reason. And the citation for that is in my testimony. In contrast, states with elected Supreme Court systems, and by the way, that's the most common system, have better Supreme Courts. In a study by Choi, Galati, and Posner, which is described in this book, Judicial Elections, they measured the productivity, independence, and opinion quality of elected justices versus justices selected through the Missouri model states. They found that elected justices were more productive, meaning more opinions produced per year. They got their jobs done faster. They were also more independent, defined as willingness to differ from their colleagues. And in terms of quality, in terms of the number of citations by Supreme Courts of other states, it was a wash. They were essentially equal. We also know that, as I mentioned, the electing system using popular elections is the most common. 22 states, that's the most frequent system used in our country, and of course Kansas used it before 1958. Polling, not surprisingly, shows that the people of Kansas overwhelmingly favor having the right to elect their justices. A poll conducted in December and reflected in my testimony said that 74% of Kansans prefer that to the status quo. And then to echo a point made by the Senate President, what about politics? That would be the argument. Well, if you have elections, then maybe you will have politics in decisions. As an attorney who's argued it in appellate cases and in Supreme Courts across this country, every controversial case has some room for ideological bias. It is a myth that cases come to the Supreme Court and that the words of the Constitution command a result that every fair-minded judge would naturally go toward. If that were the case, then you would have unanimous decisions all the time in the U.S. Supreme Court and in the Kansas Supreme Court. But of course we don't. We have dissents. Why do we have dissents? Because it is in every controversial case, a reasonable argument can be made for both sides. There is gray area. If there is gray area, that's where the judge's biases, political leanings, whether he wants or she wants them to or not, they come in. And that's why we attorneys who practice appellate law, we can tell you how a decision is going to come down when we know who the judges are on that U.S. Circuit Court opinion. When we know, or we already know the justices on the U.S. Supreme Court. We can predict those decisions because we know their political biases. So the question is, do you want to have any check on those biases, or do you want those biases to be unchecked? And I would suggest that since the decisions are inevitably in that gray area going to reflect the ideology of the judge, they should be held accountable. Right now they are accountable to no one. You and I are accountable every 4 years. We have to stand for elections. I suggest judges should be too. And one final point. It's sometimes argued that, well, maybe voters aren't sophisticated enough. This was the argument of the 1950s. We need experts. Voters aren't smart enough to do this. In this book, Bono and Hall looked at that exact question. And the way they measured it is they said, do judges prefer more qualified, do voters prefer more qualified candidates in these state Supreme Court elections? And they defined more qualified as having experience on the intermediate court or the district courts below. And they found that the more qualified judicial candidates did consistently 4 to 5% better in terms of their votes. So voters clearly were seeing which ones were more qualified. They conclude, we found that voters in state Supreme Court elections make fairly sophisticated candidate-based evaluations. So in conclusion, it's time for Kansas to be stop being the oddity it's time for Kansas to bring accountability to our Supreme Court elections. Thank you.
Thank you, Mr. General, and we'll again stand for questions at the end of the 23-minute block. Up next, we have Anthony Powell, Kansas Solicitor General. Mr. Powell, welcome to Fed and State.
Morning. Thank you, Mr. Chairman, members of the committee. I am Anthony Powell. I'm our Solicitor General, and I bring this subject to you from a little bit different perspective, having been a judge for 20 years here in Kansas, both as an elected district court judge and as a judge on the Kansas Court of Appeals, where I went through the Supreme Court Nominating Commission. I bring sort of a unique perspective to that. I'm so sorry. That's all right. There's some judges, they'd revoke, you'd take your phone if that happened to you. I think what this issue really comes down to is the people have the right to self-government. That's really what this question is about. Who gets to decide who should serve on one of our most important branches of government? And I think clearly, I think the people should decide. This isn't the first time I've testified in favor of reform. I was here 12 years ago in favor, so this is not new for me. I've consistently advocated for a different system than what we have. Our founders did not envision a government where we have a government by experts. In fact, our judicial system isn't even designed that way. We have a constitutional right to a trial by jury. Well, who are juries made up of? Ordinary people. They decide difficult questions every single day in their courtroom, and when they're presented with tough technical information, we don't have experts step in and decide those questions for them. We have experts give testimony and to inform and educate the members of the jury in order for them to make the right decision. What we can do with regard to voters electing our Supreme Court, it's up to the public, it's up to lawyers, other groups, the business community, other interest groups to inform the voters as to the qualifications and the qualities of the candidates that can serve on our Supreme Court. But I believe that the people and the voters are fully capable of doing that. Some of the arguments that you will hear against judicial elections are you undermine the judge's independence. And I want to say categorically, I think that's false. Judges are not meant to be independent of the people. They carry out the will of the people every single day by invoking the Constitution and our statutes, which are ultimately the ultimate will of the people. They do that every day. The other thing I would say is having served 10 years as an elected judge in Sedgwick County, I never once, either myself or any other judge, ever make a decision they knew was contrary to the law or to the facts because they thought the public might wish them to go into a different direction. I never once saw that. I don't believe that that is actually a threat. I believe that every judge in Sedgwick County who are all elected decide cases based on the law and the facts. And so I think you do get good judges with elections. They know that they're accountable to the voters. I found that it gave me confidence that when I was making a decision, I knew I had the support of the people because I had been elected by the people, that I wasn't just appointed. The other thing I would say in terms of quality judges, the general already talked about that. But I did a sort of an informal survey when I was on the Court of Appeals, and I went through some of our past decisions over the past year, see how many times we had reversed district judges in various cases, and I found that there was really no difference between elected judges and appointed judges in terms of their general reversal rate. It's about the same. So the quality of judges that you'll find that are elected versus appointed, I think are the same. I think you get good judges either way, but the essential quality is that the public, I think, will have more confidence in a judiciary where they get to pick the judges. The fact is, as the general talked about, we have some hotly contested legal matters that come before the court. So how do we resolve that? Prior to when Robert Bork was nominated for the Supreme Court, people that would review judicial qualifications, that could simply look at their writing ability, their experience, those kinds of things. Well, now, we have hotly contested issues. How are those issues ultimately going to be worked out? Ultimately, it has to be worked out by the people, where they select judges who they think are going to be more sympathetic to particular points of the law. Finally, I guess the one argument I would say, and I guess I've already made this point, but sort of implicit in the argument here is that we need experts, that the voters really aren't smart enough to pick our judges. And again, I think that's false. I think the voters are a lot smarter than we think they are. And it's our job, certainly those of us who are in the bar, is to educate the public as to the quality of the candidates that are running for justice. And with that, I'll stand for questions at the appropriate time. Thank you.
Thank you, sir. Up next via WebEx, we've got Robert Edmonds, former Associate North Carolina Supreme Court Justice. Robert, are you on there, Mr.?
I am here if you can hear me.
We can. Go right ahead, sir.
Well, thank you for the invitation to testify today. My name is Robert Edmonds. I'm currently teaching at High Point University School of Law in High Point, North Carolina, and also affiliated with the firm of Fox Rothschild in Greensboro. I'll keep my comments short. My role today is to present my views regarding the popular election of judges, and in a word, I support it. I've been in 4 statewide appellate judicial races, winning 3 of them. Depending on the year, some of those were partisan, some were nonpartisan, some were publicly financed, some were privately financed. In other words, I had to raise money for it. So I've lived through about every way you can run a judicial election. But even though I lost my last election, I still believe that the popular vote is the best process, though I acknowledge that none of them are perfect. My reasons for supporting judicial elections are founded in my belief in democracy, and what I say is going to be repetitive of some of the things you've already heard. But I think elections tap into the biggest talent pool. Any lawyer in good standing who has ambitions to serve on the bench can take a shot at it. And a lawyer who has those ambitions can succeed without a political godfather, without having an in with the governor or the commissioner, without having a big city practice. I had no such backing and could never have reached the bench without an appointive system. And I think that people like me should be able to seek the bench by putting themselves and their resumes out for the voters to consider. And as others have said, the elections provide satisfaction for the citizens. People want a say in who is involved in their government, including the courts. And appointive systems can rob them of that say, particularly that ability to participate. In addition, elections require that candidates, challengers, and incumbents alike have to get out and meet the voters and hear what they have to say. So judicial elections are good for civics, something we're all concerned about these days. Why? Because campaigns give judges a chance to explain a judge's job and the role of the judiciary in maintaining a democracy. Appointment systems can frustrate the will of the voters and establish an in crowd that makes it difficult for otherwise capable candidates to be considered. And as your Senate President said, ultimately all systems for picking judges are political. It's just a question of where the political element is found. And even in the purest of appointive systems, the federal systems, politics creeps in all the time. Like I said, no system is perfect, but my belief, based on my experience, is that election of judges is a sound system and has the fewest drawbacks. And I'll stick around for questions as is appropriate. Thank you very much.
Thank you, sir. We've got a little over 5 minutes left. Up next is Clark Owens, retired district judge. Is Clark online?
Yes, I am.
Okay, Clark, go right ahead.
Thank you for the time to address this bill. I am testifying in support of it. I'm a retired district judge. I served 22 years on the Sedgwick County District Court bench. The Sedgwick County is an elected district, and my fellow judges in Sedgwick County seem to support it. Anytime I've talked with them, they like the election system. And I know there are a lot of things that have already been said, but I want to add just a few things that I think have not been covered. The proof's in the pudding regarding the retention elections. The Supreme Court has never had anyone lose a retention election. The Court of Appeals has never had anyone lose a retention election. The district court in the 17 districts that have retention elections, all I could find is one person that's ever lost a retention election. And the election districts, that's not the way it goes. Incumbents do lose elections. And I think it's fair that we stand elections in front of the people and let them make a decision if they want us or not. There was an effort to try to defeat some of the Supreme Court justices after the death penalty cases. The Kansas Supreme Court reversed the first 5 death penalty cases. I had one of them that I presided over, the Michael Marsh case. And when they reversed these, in the Carr case, they finally were so frustrated that the Justice Scalia said, "Does your court even read any of our opinions?" And then he later said, "I think they don't like the death penalty." And so the voters should have an opportunity to see that and make their own decision. Is this a personal decision, or was it a decision based upon the law? The elections in 2014 and 16 were the only close elections we've had, and much of that is because there was an advocate group from the surviving family members of the Carr brothers victims. And in 14, they were retained by 53 to 47%, and in 16, they were retained by 55 to 45%. But the rest of the time, it's 65 or 70% of the time they get retained. Basically, our system is like the federal system. It's a lifetime appointment. It's very, very hard for any judge to not be retained. So first time, in fact, they ever upheld a death penalty case was in 2015, and that's after a close call of 53-47 in the retention elections. And the Supreme Court Nominating Commission really isn't any better about the initial selection, but I think that's been covered well. 5 lawyers that are elected by lawyers have the power on that. So to initially get on the Supreme Court, lawyers make that decision. The 4 citizens are a minority, and while their voices may be heard, they very definitely are the minority. But I know we're short on time. My written statements go into a lot more details, and I strongly suggest that this bill be passed. And thank you for your time.
Thank you, sir. Up next, we have Scott Blackburn, Americans for Prosperity. Scott, unfortunately, you got about 2 minutes left.
Right, let's run. I will not cover what has already been covered. I'm Scott Blackburn. I'm here as an expert in this area for Americans for Prosperity. Americans for Prosperity believes all judges should follow their constitutional duty and uphold the law. We believe this system has failed to do that, and so we support this bill, which would change it to an election-based system. Let me just skip to some of the things that we can learn from other states that would be helpful for you guys deciding this. Firstly, this is not a radical change. Plurality of states already have elections. This is not going to be a change that upsets some fundamental constitutional power. In fact, it envisions a world in which accountability is the model and is closer to how the founding, how judges were selected at the founding. Second, judicial merit selection does not produce better qualified judges. The competency of the judges, no matter how you measure it, no matter how you measure it in the research, has demonstrated that elections and merit selection produce judges that are equally competent. And third, there is obviously an ideological skew when you have a selection of judges based on the lawyers from the Bar Association selecting them. Just to put this in perspective, if the Kansas judiciary were a state voting in an election, they would vote like California. So it is not surprising that the voters of Kansas do not see a legitimate body in a body that votes essentially like California. I will yield the floor if there are any questions at the appropriate time. Thank you.
Thank you, Scott. Sorry for the rush time.
No problem.
I think we've only got about 15 seconds. Josh, I apologize. We're out of time for the proponent testimony. I apologize to Josh and I, Steve Brunk, Nick Reinecker all wanted to speak in person, but we've run out of time. Committee, there's also written-only testimony and proponents, 13, actually 14. Eric Stafford from the chamber, we missed him. He's uploaded as well. So a lot of testimony for you to pour over. I think what we're going to do, committee, is open to questions for our proponents for about 10 minutes or so and explore any questions you may have for our proponent testimony. Senator Fascadeau.
Thank you, Mr. Chairman. My first question is for President of the Kansas Senate, Ty Masterson. And then I have a quick question for Attorney General Chris Kobach. So in the bill itself, what's the significance of the dates It's got in here 2020, 2030, 2032.
From my opinion, it's just so you don't have an abrupt transition, so you have a slow transition of the court. And then all the current justices are certainly welcome to run.
Okay. Thank you, President. And a lot of times when we are having these type of hearings, we will give an example of the Carr brothers. If you would please tell me what's the difference, the major difference of not giving an, including Dennis Rader, BTK.
Oh, I just think I gave the examples of the Carr brothers because the U.S. Supreme Court was, they dwelled on for several pages the reasoning of the Kansas Supreme Court and talked about how it was, based on pure speculation. And they used terms that are really quite unusual. Usually courts are very deferential to one another, and it was pretty unusual to hear the U.S. Supreme Court talk about the reasoning of our Kansas Supreme Court in such derogatory terms. So that's why I gave that example. But I think there are lots of decisions, like that.
Okay.
Mr. Chairman, this question is just for Jason Long, our advisor. So what other states what other counties don't do this? So Cedric County, we elect our judges. Thank you.
Jason, I don't know how many counties do the election.
We can get you that information.
Yeah. Other questions, committee? Senator Tyson.
It's 14 and 13.
Okay, so
Judicial districts, 14 elect.
if you want to step up, Josh, yeah. Just introduce yourself.
My name is Josh Nye. I was a proponent testimony. On the Supreme Court website, you can see the nominating commissions for the various judicial districts nominating commissions. There are 17 judicial districts, many of which are multi-county, some of which are single county like Douglas and others that have nominating commissions. The remainder 14 judicial districts, including Wyandotte and Sedgwick, elect.
All righty. 14 and 7. Yeah, or 17. Okay, 14 and 17. Got it. Senator Tyson.
Thank you, Mr. Chairman. For the Attorney General, I want to thank you for your testimony and for the data. I think that's excellent. The 87% turned over since 2007. And you were asked about one of those cases. One of the most egregious, I know we talked about it this summer, to me, was the illegal immigrants. They could not be prosecuted by Kansas law. But would you mind giving us one or two examples from the U.S. Supreme Court overturned?
That's another good one. I think there were several in the death penalty context, and those were alluded to by some of the other witnesses. But the one you're referring to is Kansas versus Garcia. I want to say that was maybe 5-ish years ago. And that's where the Kansas Supreme Court held that our state law against identity theft could not be used, if it were used to prosecute illegal aliens, that effectively the state of Kansas was trying to regulate immigration in a way that was unconstitutional in violation of the U.S. Supremacy Clause. And the U.S. Supreme Court soundly rejected that when the case was appealed to the U.S. Supreme Court. It said, of course, Kansas and any other state can enforce their laws against identity theft. And if it does have the effect of making it harder for illegal aliens to remain in the state, so be it. But it doesn't in any way infringe upon the supremacy of federal statutes, and there is no such conflict with the federal statute. So I think that's a good example. I'm glad you brought it up of another decision where the Kansas Supreme Court made a decision that I think most attorneys looking at it, regardless of political bias, would say, yeah, that's a little hard to defend.
Thank you, Mr. Chairman. Thank you, Mr. A.G.
Senator Francisco, then Senator Clifford after that.
Thank you, Mr. Chair. Questions for Solicitor General Powell? Thank you for coming. I think you might have been one of the proponents who mentioned will of the people or will of the voters.
Yes.
So how then does this protect the minority? Which to me is one of the things that's a responsibility of
our Constitution protects our minority, and of course judges are sworn to uphold the Constitution, so that's how the minority is protected, is through our Constitution.
I appreciate that answer, but concerned because we have the will of the people electing the people who make the laws. And then the other question is, can you tell me anything about how much money may be involved in those states that have elected Supreme Court justices?
I don't know the exact figure, but it varies by state, but it can involve a significant sum of money, yes.
Okay.
Thank you.
Senator Clifford.
Thank you, Chairman. I'd like to address a question to the Senate President as he's walking up. How concerned are you about money, particularly out-of-state money and even foreign money, as we found out with Value of them both, coming in on this ballot initiative and then subsequently on the election of judges if it passes? Thank you.
Well, it's not that money's not a concern in some way, but I would clarify, just like money's involved in our elections, it's necessary to get the message out. I actually loved the language that the Solicitor General used around the jury, right? We don't put a group of experts in there, we put a group of people in there, and it's the money that brings the message to the people. It's ultimately the people are the jury, deciding who should sit in that highest position in the judicial branch. And so I think that's the key of the language in this bill of as provided by law, because we put ethic restrictions around our elections, and we'll be able to do the best we can to eliminate any of the ill effects of that type of funding.
Thank you. Thank you, Mr. Chairman.
Any other questions, committee? Senator Thomas.
Mr. Senate President, if you could step back, please. I got a quick question for you. Sorry.
Might as well hang out close now.
Well, I'm curious, and really, I guess anybody can answer this. A lot of the ideas that we have in committee and on the Senate floor, they don't just pop out of thin air. We do our research, we do our polling, we ask our constituents. Could you talk to me about, was there polling done, a survey done to ask folks about what we're currently have and what we should have and kind of what that looked like for us?
That is a good question, and thank you for it. And yeah, for those that know me and my history in the legislature, for a long time I've been a proponent of changing this terrible system, of this elitist system. And I had, for the longest time, attempted to do the federal model, right? And by the way, most Kansans think we have something like that. Very few people, general population, understand this black box system we have now. So the reason I promoted that is I believe that's what I needed to get supermajorities under this dome to get it out in front of the people to ask. So we more recently, and not just people attached to me, but other groups that have done polling that I've seen, that by far the people prefer to have that decision themselves, and I am more than happy to help them have that decision. So that's why we got here, and it wasn't just random, pulled out of somebody's back drawer, but it was thought out, and it is time to present that question to the people.
I have one quick, and then for Josh Nye, there's always some talk about the triple play. Would this prevent that from happening? I don't know if Josh is probably the right one to ask about that one, but perhaps. Where a governor.
So I do want to point your attention to my written testimony. I discussed that the triple play of 1958 was not an election scandal. We had elections for the first 100 years of our statehood, judicial elections for Supreme Court justices. That was an appointment scandal, and it had to do with a vacancy appointment in between elected terms. And so this bill would actually fix that by constitutionalizing staggered terms. I also point out that there's a unremarked effect of the current system where we have traded one triple play for systemic double plays. There has not been one Supreme Court justice in the last 22 years that chose to retire under a Republican governor. The only Supreme Court justice in the last 22 years that was appointed by a Republican governor was after a vacancy created by President Obama appointing Justice Moritz to the 10th Circuit. And so I have a table on the first page of my testimony that I point you to on that. But this systemic double play is the choice of when to retire to time that with a governor's term. As a result, we'll have 6 different justices up for retention in one election in 2028. There'll be one justice in 2026. In 2028, we'll have 6. And that's just a fluke of our system of how we start the 6-year terms. And so what I've said in my testimony is really what we did was trade a triple play for systemic double plays over the past 60-some years. And so this SCR 1611 would fix the appointment, the triple play problem, as well as this gameability of the back end of it by staggering terms and forcing these elections constitutionally every 2 years for the seven justices.
Thank you, Josh. One quick question, Senator Starnes.
Yeah, real quickly, just the hearing the testimonies and things, just this system compared to the federal model, why isn't the federal model not being looked at, or has it been in the past? Just asking.
Senate President Ty Messner, yeah.
Many times, or attempted to. We've tried the federal model multiple times, and what we see now is the electorate of Kansas really made a shift in this last set of elections where I think it's time to have the conversation yet again. But we did, and actually the polling informed it as well. We're trying to actually come to the people with what they would like.
Okay. All righty. Committee, that's it for our questioning on the proponent testimony. We'll turn, by the way, I will note, we'll probably run out of time. There's one piece of neutral testimony later on, but we'll see if we can get to that. Opponent testimony in person, 23-minute block. Up first is Fred Logan of the Kansas Bar Association, and we'll start your 23 minutes for the opponent testimony now. Fred.
Thank you, Mr. Chair, and members of the committee, Ranking Member Faust-Godot. I am here to speak in opposition to Senate Concurrent Resolution number 1611. And I would say that it proposes to place before voters a proposition that would do away with merit selection process for selection of Supreme Court justices in our state. But I think it's important for me to start with this. It was in 1958 that Kansas voters made the decision to create the merit selection process for judges in the state of Kansas. There's not been much discussion about that, but I think voters in Kansas, and I've been practicing law 48 years in this state. I've been involved in a number of public service roles on behalf of the state. It is a system that has worked extraordinarily well for our citizens. And one thing that I've learned, Kansas citizens know exactly what they're doing. They knew exactly what they were doing in 1958 when they installed the merit selection process. I think the resolution, I say respectfully, it ignores that history that caused voters to embed in the Kansas Constitution a requirement that members of the Supreme Court be chosen through a merit selection process. I believe that process ensures that individuals will be appointed to the Supreme Court because they have shown the legal skill and temperament to honorably serve Kansans. The resolution would undo that merit-based selection process for Kansas Supreme Court justices that I would argue, as a lawyer and periodically in public life like you, has served Kansans well for 67 years. The resolution would replace that process with a process that would turn on the political skill and fundraising prowess that a lawyer could bring to mounting a statewide campaign for a position in the Supreme Court. That's great for governor, Secretary of State, Attorney General. That's a good thing. Members of the Kansas Supreme Court, that should be a matter of grave concern to you, and I think would be a matter of grave concern to Kansas citizens. That's not how to select a judge. It's how to select a legislator, a state elected official, but not a judge. In the merit selection process, a 9-member Supreme Court nominating commission, having thoroughly considered applicants, recommends 3 finalists to the governor. The governor then considers the background information developed by the commission, interviews the 3 finalists, and chooses one of the candidates for membership on the Supreme Court. That's a selection process that ensures the fair administration of justice. On the other hand, political campaigns for positions on the Supreme Court and the fair administration of justice are a bad mix. Sanford Gordon, a professor at New York University School of Law, put it this way in a February 2024 article. By injecting politics into the branch of government for which independence and impartiality are indispensable, judicial elections threaten to undermine the rule of law. It is important to note that in the merit selection process, Kansans are given an opportunity to vote on whether to retain a particular member of the Supreme Court. I trust Kansas voters. The fact that Supreme Court justices have always been retained doesn't speak against the present system, it speaks in favor of it. If a justice receives a majority of the votes cast, he or she remains in office and then again stands for 6 years and then again stands for retention. A 1995 note in the Washburn Law Journal described the benefits of a merit-based selection system. Qualified attorney not wishing to participate in partisan politics would be encouraged to seek a judicial position in a merit-based system. A merit-based retention election would assure that a judge stood for retention on his or her judicial record, and minorities and women would have more opportunities for appointment to judgeships. Kansans receive those same benefits when the members of the Supreme Court are selected on a merit-based system. And I will close by reiterating a personal note. I have been practicing law in this state for almost 48 years. And one constant, in my view, has been this: the Kansas Supreme Court has been outstanding in serving our state, and the merit-based system for selecting members of the court should be reserved. We urge you to not pass Senate Concurrent Resolution 1611. I thank you, Mr. Chair, and members of the committee for the opportunity to appear, and I'll be happy to stand for questions at the appropriate time. Thank you.
Thank you, Fred. Up next, we have Ann Kindling, who's testifying on behalf of Samantha Woods, Kansas Association of Defense Counsel. Ann, welcome.
Senator Thompson and members of the committee, as indicated, I am testifying on behalf of the Kansas Association of Defense Counsel, which is a statewide organization of attorneys who devote a substantial portion of their practice to the defense of civil cases, including those cases on appeal. I am not going to repeat the written testimony that Ms. Woods has submitted, but I wanted to make just a couple of points in opposition to Senate Concurrent Resolution 1611. Judges, with the election of judges, the risk is that judges may refrain from applying the rule of law in order to make a publicly popular decision or to avoid being the target of attack ads, or judges may yield to the prejudices of the day. Even if there is only the perception of impropriety, with judges being beholden to funding groups, special interest groups, et cetera, that help them get elected, even the appearance of impropriety destroys the public's confidence in the judicial system. I heard a couple of things from earlier testimony by proponents. I believe that Judge Powell and Senator Masterson noted that juries which are made up of the public already decide cases. I want to remind the committee that juries decide facts, judges decide law. It's important that the merit selection process be maintained in order to uphold the ability to apply the law. I also noted a comment that judges are already sworn to uphold the Constitution, and that is the case whether they are elected or selected through the existing merit selection process. Senator Francisco previously asked a question about the makeup of the Judicial Nominating Commission. I want to remind this committee, I have heard several times from the proponents this morning that a supermajority of attorneys decides who the judges are. The commission is made up of 4 attorney members, one from each congressional district, as well as 4 members of the public, 1 from each congressional district, and then there is an attorney chair. So of the 9 members of the commission, 5 are attorneys, 4 are non-attorneys. It's not a supermajority of attorneys by any means. I have personal experience in my 30 years of practice in Kansas, which began as a research attorney for Justice Bob Abbott of the Kansas Supreme Court. I had experience serving on a federal magistrate selection committee, and I can assure this committee that the voice of every member of the commission is heard and evaluated before decisions are made and recommendations are made to the governor. There's no evidence that the election of judges would result in any better, more qualified judges to serve on the Kansas Supreme Court. To safeguard the neutrality of our justices, KADC urges you to reject Senate Concurrent Resolution 1611. One additional point I would make is that I have been in the Capitol. I think I started testifying regarding efforts to change the current selection process back in the mid-2000s, probably 2004, 2005, 2006, 2007, when I was president of KADC. And it's a repeated issue that comes up, but there's no evidence that there's any improvement beyond the current merit selection process. So again, we encourage you to reject Senate Concurrent Resolution 1611, and I'll stand for questions at the appropriate time.
Thank you, Ann. Well, again, like we did with the proponents, open for questions at the end of the block. Blake Shewart, private citizen on behalf of Hutton and Hutton, Schaumburg, Johnson, and Bergman. Blake, welcome to Fed and State.
Good morning, Mr. Chairman, members of the committee. Thank you for your time. I've submitted written testimony as well, and there's several other conferees, so I'll be very brief and to the point this morning. We're discussing a system that has served us well in this state and lawyers and our clients for almost 70 years. It's a nonpartisan nominating commission which sends 3 names to the governor. The commission doesn't select the justice. They send 3 names to the elected governor. There's 9 members of the commission, a lawyer voted upon by lawyers in the state to serve as the chairman, and then 8 other members from the 4 congressional districts. 1 lawyer for each congressional district and 1 private citizen appointed by the governor for each judicial district. And collectively, those 9 individuals submit the 3 names to the governor, who selects the justices, 7 of them, who take an oath to swear to support, protect, and defend the United States Constitution and the Constitution of our state, and to follow the Code of Judicial Conduct. All of those justices must stand accountable to the voters of Kansas for retention at the next general election. Every 6 years, they are voted upon and can be removed from office on any election for incompetence, unethical conduct, or for any other reason. In 2022, 6 of those 7 justices were up for retention. And of the 6 justices, the lowest percentage of vote supporting retention was 64.7%, and the highest percentage supporting retention was 72.9%. So that's roughly 2/3 plus of the voters voted to retain all 6 justices. The voters are smart enough to make these decisions. No one has contended otherwise. And in fact, I believe that if the proponents of this bill had some data to show that justices were being removed in retention elections, then they would turn around and contend that that was proof as to why the justice needed to be voted in. Now, this is not a day in, day out job by our justices to press the lever on state politics, decide elections, school funding, reproductive rights, or any other things. Those cases do come around every so often. But what they do every day, week, and month of the year is roll up their sleeves, read briefs, learn cases, ask good questions, listen to good lawyers argue, deliberate, decide cases fairly based on even-handed application of the facts to the law, and then they sit down and have to write a long opinion, 20, 30, 40, 50, 100 pages, that's available to every citizen in this state to help them understand why they voted the way they did. And last night I went and looked back at the last 50 or so cases that our Supreme Court has decided. This ranges back to July 26 of last year, roughly 7 months. 52 cases over the last 7 months. 31 of those, 60% were criminal. 20% of those 31 were murder cases. 7 of those cases were attorney discipline, 1 involving a court reporter. And of the remaining 14, 3 of them were determining whether to award compensation for wrongful conviction. The Supreme Court determined in all 3 cases that the criteria had not been met and that there should not be an award. Then the rest of the cases were parentage, adoption, a gambling license, 2 civil garnishments, a tax valuation, a zoning code issue, a public nuisance issue between 2 farmers, and a construction case. These are the cases that our justices decide. The crucial work that they do to delve into these statutes, the trial records, and make important decisions of great consequence to every citizen of this state. Even if most don't read their opinions, the lawyers do. The lawyers who must learn how to handle their next case, to represent their client as skillfully and as ethically as possible, and how to follow the law. And then the lawyers that must turn around and vote on those we respect to contribute to the decision of who should serve on our Supreme Court by serving on the nominating commission. The lawyers who stand before you today want to protect a system that has served our clients well for 67 years, win or lose. Thank you.
Thank you, Blake. Up next, we have Nicole Revenaugh. Hopefully I'm pronouncing that correctly. Women Attorneys Association for Freedom. We've got about 9 minutes left.
Thank you, Chair Thompson, Ranking Member Falscadeau, and members of the Senate Committee. My name is Nicole Revenaugh. I am appearing today on behalf of Kansas Women Attorneys Association for Freedom. We are an organization that serves to advance, promote, empower, and protect women both in and out of the state of Kansas. Our organization opposes SCR 1611 and the election of judges, as well as the abolishment of the Supreme Court Nominating Commission. Our members are statewide and represent a variety of clients, everything from criminal prosecution to tax advice, corporations, plaintiffs, and defendants. We believe that, and we all agree, that maintaining the independence of our judiciary free from political influence is best both for our clients and for the state of Kansas. I'd like to refer you all to our written testimony, but I will not bother you to repeat it. I'd like to just speak to a few points that I believe haven't been raised yet. As other members spoke, we have never had a justice that was not retained. To me, that means the system is working and working fairly. The proponents of this bill have brought up several individual cases containing decisions that they strongly disagree with. As a lawyer and practitioner, we may not agree with every decision as legal scholars or even as citizens reading about these decisions in the news. But we unanimously agree at the time for retention election that these justices are qualified to continue serving and sitting on our Supreme Court. It would chill and infringe on our justices' ability to render fair and impartial rulings if they believed but a fair and lawful ruling, yet a controversial or unpopular one, would lead and result in their ouster. Senator Francisco asked earlier about the amount of money coming in from outside the states for states in which they have elections for Supreme Court. And I'd like to bring up the example of Wisconsin, which recently did have a Supreme Court election. In that recent election, 45 million of the 51 million invested into that election came in from dark money outside of the state of Wisconsin. If that was repeated here, it's clear the overwhelming implication is that Kansas and Kansas citizens would not be controlling our elections or who is put forth for candidacy. Dark money is. Proponents outside the state would be. And that is not in the best interest of our clients or for the state of Kansas. If that system was imposed and everyone could read about the amount of dark money that came in to these elections, our citizens would question the validity and reliability of a system that would allow lawyers and those outside the state representing special interest groups or maybe even foreign entities to donate to a justice's campaign and then hope that that same justice would actually provide a fair and impartial ruling later. Finally, I want to mention that we have a great bipartisan tradition here in Kansas of electing both Democratic and Republican governors. That means that at reasonable intervals of time, we have had each party essentially being permitted the ability to choose among the 3 remaining candidates from the Supreme Court Nominating Commission. I think that that's created a very balanced Supreme Court, representing whatever bipartisan interests you may think that justice may tend to. But at the end of the day, both parties and governors from both parties have had a say in the selection of our justices, and I think that has created a fair and impartial system. We urge this commission to oppose SCR 1611, and I will also stand for questions at the end. Thank you.
Thank you, Nicole. Up next, we have Rashane Hamby, UCLA of Kansas. And we're down to about 4 minutes or so, Rashane.
Good morning, Chairman Thompson and members of the committee. My name is Rashane Hamby, and I represent the ACLU of Kansas as the Policy Director. I will keep my remarks short because you have my full written testimony. On the behalf of our 35,000 supporters across the state of Kansas, I strongly oppose this resolution. This resolution seeks to dismantle Kansas's merit-based judicial selection system and replace it with partisan judicial elections. This would inject politics into our courts, undermine political independence, and erode public trust in the judiciary. This threatens the rule of law, weakens the separation of powers, and allows special interests and partisan agendas to influence our highest court. Under the new system, Supreme Court justices would run in partisan elections, requiring them to campaign and fundraise from political parties, including special interest groups and donors who may later appear before them in court. It would allow Supreme Court justices to engage in political activity, including contributing to and holding public office within political parties, which would make Kansas actually an extreme outlier. It would also allow Supreme Court justices to respond to voter pressure and political attacks. The dangers of this partisan system are well documented by the American Bar Association, which has noted that systems like this has an increased political influence over court decisions, soaring campaign spending often fueled, as noted earlier, by dark money groups, and also shows a decline in public trust as judicial decisions become tied to political interest. Kansas's current system ensures that justices are selected based on qualifications and merit, not political affiliations. If this passes, Kansas will become an outlier among U.S. states, abandoning safeguards that protect judicial integrity. So here are some lessons from other states. As noted earlier, Wisconsin had $45 millions of dollars of dark monies funneled into the state. In Texas and Pennsylvania, justices routinely receive large campaign donations from corporations and law firms, creating clear conflicts of interest when those donors appear before them in court. In Arkansas, political gridlock in the state's Supreme Court has eroded public trust in judicial fairness. In Kansas, we should not invite these problems into our judicial system. The Supreme Court should not be for sale to the highest bidder. If this passes, it will be a radical departure from Kansas's long-standing commitment to judicial independence. The merit-based selection system has served Kansas well for more than 6 decades, ensuring that justices are accountable to the law and not political parties, special interest groups, or campaign donors. This proposal threatens to corrupt Kansas's highest court, inject partisan influence into judicial decisions, and dismantle our constitutional safeguards that protect everyday Kansans. Thank you.
Thank you, Rashane. Finally, Mike Fonkert of Appleseed Center. We've only got about 45 seconds if you want to chime in real fast, Mike.
Is there anybody after me?
There are 2 people after you as well.
I'll yield my time to the next speaker.
All right. Dave Morantz on behalf of Kansas Trial Association. Dave.
Thank you, Chairman
Very,
Thompson.
very short.
Very short. Evidence is important in the court of law. Evidence should be important in this body as well. Regarding the overturn rate of the Kansas Supreme Court, if you go back to the mid-60s, when our court had a majority of merit-selected members, the overturn rate was 66% in the U.S. Supreme Court. Nationwide, the overturn rate was 77%. We are not an outlier. We are not the most overturned court in the nation. Moreover, our Supreme Court Nominating Commission is not an outlier and is not a unicorn. Only 6 states that have nominating commissions have a majority where non-lawyers make up the majority. And the vast majority of nominating commissions, lawyers make up the majority, excuse me. I'm trying to be quick. I understand I'm probably out of time.
We're out of time.
I'd
Thank
be
you.
happy to answer any questions, though, at the appropriate time.
Yeah, and we will open to questions then for committee. First, committee, I will note at the very end, we have neutral testimony. It was supposed to be in person by Clay Barker from the Secretary of State. He'll just stand for questions if you have any, but there is, you might look at his testimony. There's a suggestion about filling vacancies, some language we might want to consider with that. And for that, for the next 10 minutes or so, we'll open for questions from the committee for any of the opponents. And Senator Tyson.
Thank you, Mr. Chairman. I do have a couple of questions, actually. The first would be for Mr. Logan. You basically, thank you for your testimony. You talked about the voters understanding and knowing, and I would ask, so when there's a retention election, there's no opposition, so there's no choice. It's just a yes or no, and most voters drop off at the end of the ballot. And we saw in the retention election a few years ago that the justices actually ran commercials. So they're campaigning already. Would you please address that? Thank you, Mr. Chairman.
Well, I will say this. I'm going to start with the latter part first. That may exist in a very select instance or two, but nothing like what you're going to see if you start having election of judges and the kind of fundraising that you're going to see. And let's not kid ourselves, it's going to take on a national impact. And it will be huge sums of money that will go into that. That just simply doesn't exist. I would argue that the retention elections have not generated controversy because the service has been so stellar overall for many years. And I go back to what I started with before. One has to go back to Kansas voters. I have a lot of faith in Kansas voters because, as I say, I've viewed it as a lawyer and then in various public service roles. And they know what they're doing. And I think they know what they're doing when they vote to retain these justices.
Thank you, Mr. Chairman. I agree with you. The voters do know, and that's why we should give them an opportunity. I agree with you on the dark money too, but you said it's not pouring in now, but we have seen evidence of dark money coming into Kansas. So let's work together on that and shut that down. Thank you, Mr. Chairman.
Senator Fascadeau.
Thank you, Mr. Chairman. My question is for Nicole. Nicole, if Senate Concurrent Resolution 1611 were to be enacted, how would it affect when constituents, voters, Kansans, when they make a complaint against a judge or an attorney? How would this legislation affect that process?
Thank you for your question, Senator. The Association of Attorneys statewide, we are all subject to ethical rules and regulations. We have our own code of conduct. And you're right, any citizen, any client, any individual who feels that they have been wronged by either their counsel or a judge can file a complaint with that independent governmental ethics board for attorneys. I don't believe that SCR 1611 would change that unless I'm misunderstanding anything in the bill. I think it would still exist separately. So there is a mechanism both to report misconduct on behalf of an attorney or judge that exists in the law. I'd like to point out that on times where the citizens have believed that system has fallen short, there was an instance in Sedgwick County when the voters did vote not to retain a specific justice or judge in Sedgwick County after misconduct had come to light that the citizens didn't believe the ethical attorney and judge review board had handled appropriately. So I believe that system is working well together. Thank you.
Any other questions? Senator Gossage.
Thank you so much, Mr. Chair. This question, I guess, best would be for Fred. Thank you so much for coming up. I find it interesting that I'm looking at all the opponent testimonies, and by and large, the majority of them would just protect the elite association's exclusive authorities to select nominees. It's kind of like you're saying, I have faith in the voters, but yet you're not giving them an opportunity. So what you're really saying is, we've been doing this for a long time. We want to continue to have this elite ability to do that. Is that what I'm hearing you say?
No, I'm not. I'm saying that Kansas voters, I have enormous faith in Kansas voters. And in 1958, they knew exactly what they were doing in the wake of some very serious issues that had come up. And I am saying that they know what they're doing, and they like the system. They like the present system. There's no movement from Kansas citizens, in my view, for making this change. And I respect those who are making the proposal, but they don't necessarily represent the views of Kansas citizens. I think Kansas citizens like the system.
And one more, if I may, Mr. Chair, and that is, I think someone said people are not, they may act differently from the bench if they're worried about ouster. But how is that any different than now when they'll be voted on in 6 years?
I think the graver danger is that judges having to go out and raise campaign money. I've been in a position where I've done that. You've done that. That's politics. That's fine. But think about people who are arbiters of the law, and that's what they're thinking about. Maybe they're sitting there and an attorney makes substantial or ranges for substantial donations. How would you feel if you're the party on the other side? It's a bad mix. Fundraising and the judiciary is a disastrous mix.
If I may, Mr. Chair, so, you know, somebody said something about that judiciary should not be to the highest bidder. I think that's kind of what you're saying at this point. But then we would say then the governor is, or the Senate is. I know when I went out and walked door to door for months and met constituents at their house, and they got to know me as a person. We don't know the judges as a person. And so when they go to vote for retention, it's like, well, I don't know, I guess aye for all of them. I haven't heard anything bad. But they don't really know who this person is. Wouldn't it give them an opportunity to prove, like, I'm an impartial person, this is what I've done so far, to their constituents, to the people who would be voting for them?
I'm a strong believer that we have a brilliant political process for people who are in that process. I would not want to make a change on it. But when you talk about the judiciary and the expectation of the impartiality of law, that doesn't mix with the political process. That's why Kansas voters instituted the system that they did in 1958, and it has served our voters and our constituents very well.
Senator Francisco.
Thank you. I hope 2 quick questions. One for Fred Logan, and that would be can you tell me about the schedule of work for Supreme Court judges that would allow them reasonable time to campaign during an election year?
I believe that in Kansas, our judiciary from top to bottom is very heavily worked. They have very heavy caseloads. I think that the work of the Kansas Supreme Court is very heavy. It's a real burden to be a justice on the Supreme Court. I mean, it's a commitment of time. And the idea that all of a sudden now you're going to be raising funds, going out and electioneering, it's difficult to imagine. It's a colossal sea change for Kansas.
And then one question for Ms. Kindling. And I certainly appreciate your work on this issue for a number of years. So I have a concern about just again the way that the ballot explanatory statements are written, and it just talks about the current system and describes it. Can we describe this current system as a merit selection process? Is that something that would be understood?
I believe yes. I think that describing it, instead of describing it as it says, current system in which the vote no explanation stresses by its very language that that the membership of the nominating commission consists of a majority of lawyers. I think that it would be better stated to explain more about the process, that the nominating commission consists of members, both public and attorney members from throughout the state who, and again, I'm going to say they work very hard to ensure the qualifications of the names that are submitted to the governor. So at a minimum, that I agree with you, Senator Francisco, that the explanation of the vote no really does not adequately explain what it would be, what a no vote means.
Thank you. I appreciate that. And also note that consists of a majority of lawyers is a statement in part of the vote for this proposition.
And then Senator Blue.
Thank you. My question is for Fred Logan. I haven't heard much from the opponents or at all about the federal model. Do you guys support the federal model? And if not, why is it flawed?
I think the federal model is vastly outranked by the Kansas approach. I think that the confirmation hearings at the federal level frequently have deteriorated into kind of showboating. With no insult intended, go online sometime and watch then Senator Joseph Biden's questioning of John Roberts when he was nominated to be the Chief Justice of the Supreme Court. It was not a pretty picture. And so I don't think it adds anything. And I think the federal model proves that. Now, these people are going to go through a very difficult process with this committee. They're going to make recommendations to the governor. The governor's going to get a full report. The governor's going to question and interview these people. It's a good system.
Hey, committee, we're about out of time. If yeah, go ahead, Senator Tyson, then I have one quick one.
Thank you. Well, I know that you might think, I don't know, I'll just throw this out in general. The appellate system used to not have any oversight or over approval, and we added Senate confirmation. And there was an appointment just recently, last few years, the governor appointed, and if we wouldn't have changed that system, he would have been appointed to the appellate court. He did not receive one positive vote, not one. So why don't you think there should be checks and balances outside of the lawyers for our selection of state Supreme Court justices?
I think that there's an outstanding system of checks and balances in the present system through the Merit Selection Committee and then the governor interview. I think it's worked very well.
Do you have a follow-up?
Thank you. I would just comment that I would ask committee members and others to go out and read some of the justices' opinions and decide.
And I have, and there's some concern in there. I have one quick question for Ann Kendling. Very quickly. You've got the chair of that nominating commission is an attorney, so they have tie-breaking authority, correct?
Tie-breaking authority, yes. Again, I don't have experience with the Supreme Court nominating committee, or commission, but when I served on a federal magistrate selection commission, the chair of that committee did not weigh in unless needed. And again, for the most part, it was providing information.
Try not to make this a long, winding follow-up question. Sure. I was a meteorologist for years, member of the American Meteorological Society. And when you're a member of a professional society like that, it confirms legitimacy on members of that society. However, when the society changes and they stop basing things on science and facts, and you have to leave that professional organization because you don't believe in how they're doing things, people lose grant money, people lose research foundation money and things of that nature. How is this not dissimilar to what happens in the Bar Association? If you don't conform to a certain belief system to conform to be nominated, because there is a preponderance of attorneys on that commission. Do you understand my question?
I'm not sure I completely follow it, to be honest.
In other words, if you don't conform to a certain belief system, you're not going to get nominated. The same way, if you don't conform to a professional society's belief system, you either go along to get along or you get out.
I would disagree with that, Mr. Chairman, for the reason that the nominating commission consists of, there is no, although, again, 5 members are attorneys, they're not weighted to a certain political belief or leaning. You've heard today from a representative from the Kansas Trial Lawyers Association. They primarily represent plaintiffs in personal injury matters throughout the courts in Kansas. I myself am with the Kansas Association of Defense Counsel. We defend those cases. Mr. Logan, Kansas Bar Association, you also heard from, who represent, and the Kansas Bar Association represents all attorneys in Kansas. So applying to be a judge has nothing to do with a political leaning like election of judges would result in, if that answers your question, Senator.
Thank you. Committee, we are out of time. We will close the hearing on Senate Concurrent Resolution 1611. We thank you, everyone, for your Senator Francisco.
Mr. Chair, I was just wondering, because a comment was made about the funding for the retention elections when the 6 justices were out, could we ask our research staff to give us some information about that? I'm remembering that it was not the individual judges, but a group that organized for support, so I'd be interested in
Elena, did you get that? Okay, understand it? Okay. And spread that to the committee when you get that as soon as you can. Senator Gossage.
I would just add, you know, we currently have limitations for each level. When somebody is elected, we would do the same thing, obviously, if the voters would agree on this amendment.
Obviously, that would be something we'd have to talk about.
Limitation. Thank you.
Thank you, Senator. Okay, we've closed the hearing on SCR 1611 committee. Tomorrow, we're going to have a hearing on HB 2106. Thank you, everyone, for your testimony and for your indulgence in time. And with that, we